Judgment in the matter of OWD Limited, trading as Birmingham Cash and Carry in liquidation and another, versus Commissioners for Her Majesty's Revenue and Customs.
Lady Black will explain the judgment of the court.
This appeal concerns wholesalers supplying duty-paid alcohol. In 2015, a new regulatory scheme was introduced by the Finance Act 2015, under which such wholesalers couldn't trade unless they had approval from HMRC. HMRC could only give approval if they were satisfied that a wholesaler was a fit and proper person to carry on the activity. The wholesalers in this case were already trading when the scheme came in. They sought approval to continue to do so, but it was refused because HMRC were not satisfied that they were fit and proper. They appealed to the First-tier Tribunal against the decision, inviting HMRC to permit them to continue trading whilst their appeals were pending. HMRC refused to do so. The wholesalers brought judicial review proceedings challenging the refusal of temporary approval and seeking an order that would permit them to continue trading until their appeals were determined. The outcome of the judicial review proceedings ultimately left both wholesalers and HMRC dissatisfied, and both appealed to this court. Two principal questions require to be determined. The first question is whether, having refused an application for approval, HMRC have power under Section 88C of the Alcoholic Liquor Duties Act 1979 to permit trading to continue pending the outcome of an appeal by the wholesaler to the FTT. This court decides that there is no such power. Section 88C(1) provides that a controlled activity, that is the wholesaling, may not be carried on otherwise than in accordance with an approval given by HMRC under the section. By Section 88C(2), HMRC may approve a person under this section only if they are satisfied that the person is a fit and proper person to carry on the activity. The section permits approval for limited periods and subject to conditions or restrictions, but it does not empower HMRC to grant temporary approval to tide the trader over during the currency of an appeal where, as here, they have already reached the conclusion that the person is not fit and proper to carry on the activity, even for a limited period and whatever conditions might be imposed. If the person is not fit and proper for even a limited period of time, that holds good whatever purpose the time-limited approval would be designed to achieve, and whatever the impact upon the person or his business of refusal of approval. The second question is whether HMRC can give temporary approval pending appeal under Section 9 of the Commissioners of Revenue and Customs Act 2005. That section permits HMRC to do anything which they think necessary or expedient in connection with or incidental or conducive to the exercise of their functions. This court decides that it cannot be said to be necessary or expedient in connection with the exercise of HMRC's functions to grant approval to someone who they are not satisfied is fit and proper and could not approve under Section 88C. An ancillary question arose during the course of the appeal concerning the powers of the High Court to grant injunctive relief to assist a wholesaler pending his appeal to the FTT, and in particular as to what form a High Court order could legitimately take where a case for injunctive relief was made out on the basis that the wholesaler's Article 6 rights would be infringed by virtue of the business ceasing to be viable before his appeal to the FTT could be determined. Various possibilities were explored, and the court expresses its uneasiness as to whether there is any order at all that could properly be made by the High Court. It does not, however, decide the point, as it's unnecessary to do so on the facts of this case. Lord Hughes, with whom Lord Sumption agrees, observes that it might be necessary for those responsible for legislation in this field to give attention to the possibility that the present legislation might be incompatible with the European Convention on Human Rights, where there are traders who were in business at the time the registration scheme was introduced, who have good grounds of appeal against a refusal of approval, and who might have their right of appeal rendered nugatory by being forced out of business before it could be determined.